Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hey, everyone. Welcome to our Curious Amalgam. I'm Lexi Michaud, your host for the day, and I'm joined by Anant Raut, my co-host and the host of our sister podcast, Trust and Trade. Hey, Anant.
Hey, Lexi. Always great to be back on our Curious Amalgam. And great topic you have for us today.
Yeah, I'm very excited about today's topic. We're going to be talking about reverse acquihires, which some of you may have seen in the news lately. I've certainly been following them in the news. And they seem to be a growing trend, especially in technology and in AI. And they raise big questions for competition law, including whether or not they are skirting Hart-Scott-Rodino reporting requirements. So to discuss those issues and others with us today is Sam Weinstein. Would you introduce our guest, Anant?
Sam Weinstein is a professor at Cardozo Law School and a former counsel to the Assistant Attorney General for the Department of Justice's Antitrust Division. And he and two co-authors recently wrote a paper that's coming out in the NYU Law Review later this year entitled No Exit that discusses the very phenomenon we're going to be talking about here today. Sam, welcome to the show.
Thanks so much for having me. Really excited to be here.
Welcome, Sam. We're excited to have you. So we're going to start with the basics. What is a reverse acquihire?
Sure. So reverse acquihire is a transaction structure where a big company, say Microsoft, approaches a smaller company, say Inflection AI, and says, we're going to take some of your employees, maybe your founders and your best engineers, and we're going to write you a big check, say $650 million for a non-exclusive license to your tech. And we're going to write you a maybe slightly smaller or maybe much smaller check to ask you not to sue us for poaching your employees. Right? So there'll be a pot of money, let's say $680 million to affect this transaction. So Microsoft gets the employees, the key employees, it gets a non-exclusive license to the tech, and it gets a waiver from the target company saying, we're not going to sue you for having taken our employees. So that's a reverse acquihire. And it looks a lot like an acquisition without actually being an acquisition.
Right, Sam. And how are they different from acquihires?
So that's a great question. So the traditional acquihire, which is something we saw in the 2010s and 2000s, that's an actual acquisition, right? So in that kind of structure, the acquirer buys the company, and they do it not because they necessarily want the company, but because they want the talent. And there's a really good article about this by John Coyle from the 2010s, talking to people in Silicon Valley about why they did traditional acquihires. I think there are a number of reasons why a company would do a traditional acquihire. With the alternative being we're just going to hire away your talent. The idea is we'll buy the company. And when you buy the company, a couple of things happen. Everybody saves face, right? The founders can say the company was acquired, everything happened as it should, and the investors get at least a nominal payment, right? So everybody can go on and say we had a success. Really, the company was probably going nowhere, and this was a way for them to exit, again, in a way to save face. But, the big company gets the talent, and that's what they really wanted. So that's a traditional acquihire. So it's an actual acquisition, as opposed to a reverse acquihire, where you are getting the talent, and you're writing probably a much bigger check, but you're not actually acquiring the company.
So in the case of a traditional acquihire, like the ones you're describing, the transaction would be HSR reportable. But in the case of reverse acquihires, what we're seeing is that they aren't be reported. Is that right?
Yeah. So I would say that's correct theoretically, right? So the traditional acquihires were typically very small, and they typically wouldn't be above the HSR threshold. But if they were, they would be reportable, right? So they're an acquisition like any other acquisition. If they they go past the thresholds, they're going to be reportable. These reverse acquihires are not reportable, and the reason why is the money, the payment, which often exceeds the HSR thresholds, is for a non-exclusive license, at least nominally. And so, because it's a non-exclusive license, it's not a reportable transaction under HSR. That seems like the point. I mean, we'll talk about this some more. That seems like why these transactions are designed the way they're designed. So you can spend a bunch of money. Some of these transactions are in the billions of dollars, and not have to report the transaction to the antitrust agencies.
Right. That all makes sense. And why is it a problem for antitrust? Why are we interested in it today on this competition podcast?
Yeah, sure. So if it's okay, I'll talk a little bit about the article. So this is no
please.
so I can get around to your question. So this is an article I co-authored with Brian Brofman, who's at Vanderbilt University School of Law, and my Cardozo colleague, Matt Wansley. And they're both venture capital experts. So the article is about what happens when the ability to merge is restricted by enhanced enforcement at the antitrust agencies. So you go in, you might think, as a starting assumption, that if it becomes more difficult to merge, what firms will do is they'll IPO instead, right? So if you think about the two standard exit options, going public through an IPO or being acquired, you might, if you narrow one option, you'd think firms would flow to the other option, right? So we're arguing in the paper, though, is that it's not really what's happening, right? So, we talk about how in the Biden administration, startup acquisitions in particular got attention that they hadn't gotten before. The Biden administration across the board in the antitrust agencies made it more difficult to merge. And instead of just seeing sort of all these transactions that would have been mergers becoming IPOs, we're arguing that, some of these firms decide we're just going to stay private. Right, or we're going to do something else. We're going to use a continuation, venture capital continuation fund, and stay private longer. We'll deal with, paying off our employees and our investors through the secondary markets, or we'll restructure our transactions, and that's what we're focused on today. We'll restructure our transactions in ways that evade the antitrust laws. So in the paper, we talk about two structures. Reverse acquihires I'll get to in a second. So we first talk about centaurs, which are when a public company invests a bunch of money, billions and billions of dollars into a private company, but does so in a way that avoids an HSR filing. Right. So this might be, for example, a company like Google taking a big stake in a private AI company, but doing so not by buying voting shares, right? By buying other types of shares that aren't reportable, or the target company is a non-corporate entity and the public company doesn't take control, right? So we're seeing some of these transactions in the AI space. And then there's the reverse acquihire, right, which is another way of doing this. As we talked about before, it's a way to write a big check that would, normally trigger an HSR filing, but to do it in a way that avoids HSR, right? And so we're arguing in the paper that, these are all reactions to the crackdown on merger activity, and particularly crackdown on startup merger activity, right? So this is, firms reacting to the environment at the antitrust agencies.
And Sam, just to clarify for our listeners, and I know that you started the episode by discussing this, but just wanted to go over the elements of what you see as being necessary for reverse acquihires, because just writing a big check, hiring away employees, that's fine. But there are a couple of other elements in particular that make these problematic. And what are those again?
So the typical structure is, the employees leave the target, join the big firm, or some of them leave, right? The key employees, the founders, join the public company. Public company writes a check for the non-exclusive license, but I think the size of the check matters, right? Because what you're getting in return is the non-exclusive license, right? Which again doesn't trigger HSR, and at least in some of these deals, you're getting a waiver saying we're not going to sue you for poaching our employees. Right. And then the target company is going to disperse that money, so hundreds of millions or billions of dollars, to their investors and to some of their employees. Right. But what it looks like is a payment to the VCs. Right. It's a payment to the investors, but it's not the nominal payment that you would have had in a traditional acquihire. It's a real payment. Right. It's a big payment that, is some multiple of their investment as you would have in a traditional acquisition.
So we have these reverse acquihires. We know for now they haven't been reported. We know of at least two situations where they have been investigated by DOJ and FTC, right? I think we have Microsoft Inflection and Google Character AI, at least two examples where they are being investigated from what we know, but nothing has come out of those investigations yet. Is that right, Sam?
That's right. So we if we broaden the lens a little bit, the Europeans have looked at this, and they found at least Microsoft Inflection, I think, to be a merger, right? So they've looked through the structure of the transaction to its substance. In the United States, we have reports that as you said, the DOJ or the interest agencies are looking into these deals. Sort of unclear what they mean by that. I assume it means we're looking to see if you've evaded HSR. We can talk a little bit. We're talking about HSR right now. We can also talk about the substance of the deals and if they'd be a problem under Section 7 of the Clayton Act. But I take them to be saying we're looking at this to see if it's in an HSR violation.
Yeah, so I guess to Anant's point, just to go back to why you would want to look into these deals, why these two? There have been other examples of reverse acquihires. Why do you think DOJ and FTC are looking at these two? So Microsoft Inflection and Google Character AI, why those two specifically? What is it about those reverse acquihires that you think led to them being investigated?
That's a great question. I'm not sure why those two, I think there's 5 or 6 sort of well-publicized reverse acquihires at this point, all with big checks being written. So it's not necessarily clear to me why those two have caught the eye of the enforcers. Microsoft Inflection, I think, if I were to speculate, it's one of the first. It got a lot of press. It seemed to sort of set the tone or lay out the format for these other kinds of transactions that we're seeing. So maybe that's why. Maybe there's a whistleblower, but I'm not sure. And in terms of the agencies looking at these reverse acquihires as potential HSR violations, there is an HSR rule. This is 801.90, which is the anti-evasion provision in HSR, which says that the agencies are required to look through the structure of the transaction to the substance. And if in substance these look like acquisitions that ought to be reported, then not reporting them is a violation. So that seems like the right rule to look at. I would caution, however, that the agencies are pretty conservative in the way they apply this rule. So they apply a but-for test, which is essentially, but for the evasion, would you have structured the transaction this way? Right. So they allow firms a great deal of latitude in the way they structure their transactions, which I think makes perfect sense. And it's only, a violation if you look at the transaction and you ask, but for the evasion, would you have structured it this way? So it's a tough standard, but I think, maybe these transaction structures, hurdle that bar, right? I would ask, but for the evasion, would you come up with a transaction structure that looks like this? And I would say, I think not, right? I mean, that's just my point of view. I think that these look pretty clearly like antitrust evasion or HSR evasion devices.
Right. So that's HSR. And then just thinking about some other types of harms, some other concerns we might have here. You briefly touched on what happens to employees in these reverse acquihires, what happens to workers. And that obviously has been a key priority for the agencies for a couple of years now, not only in the US, but also internationally. So how does that fit in to this conversation?
Yeah, so it's like the rest of the economy. Like the people at the top are going to make out like bandits and some people at the bottom are going to get left behind, right? So if you're one of the employees who's switching firms, you're likely to get a huge pay package, as we've been reading. You're probably, the founders and the top employees are going to get those pay packages. And then there are going to be at least some employees left at the shell. Like, the target company is now just a shell, right? It's the key employees have left. They've done the non-exclusive license to the acquirer. And if you're at the target company, unless you have some kind of contractual obligation to get paid, you're probably not going to get paid out, right? So the money that is being transferred across is to the shell is typically going to go to the investors. And if you're just a standard employee, you're probably sort of going to be left behind, right? So if you had expectations of an exit, liquidity events, that's probably not going to happen. Whereas if you were acquired in a traditional sense, or you went public, employees with options or with restricted stock units would get paid, right? So we are going to see some folks being left behind in this kind of transaction in a way they wouldn't be if it was a more standard acquisition or an IPO.
I think that's an interesting point that Lexi has raised, this tension between competing goals of antitrust, of preventing acquisitions that are harmful to competition, but at the same time promoting liquidity, the labor market. I'm sympathetic to this argument about keeping the flywheel going. You have these people who want to be entrepreneurs, and then they connect with investors who want to return on their investment, and they create this startup, and then they're able to sell it to a much larger company so that the investor get money back, and these inventors and entrepreneurs can keep going and doing what they're good at and what they enjoy doing. What's the right policy approach here, Sam? Should antitrust be trying to encourage investment, exit, and liquidity?
Yeah, it's a great question. So, I think in the first instance, antitrust enforcers ought to be law enforcement officials and enforce the law as they see it. For a long time, I think, as we all know, startup acquisitions, if they were scrutinized at all, they weren't challenged, right? So it wasn't until the end of the first Trump administration that we really started to see challenges to startup acquisitions. And I think there's lots of reasons for the delay in starting to challenge those. I don't think there's anything nefarious about it, but it was just difficult to figure out theories. We're talking about nascent competitors here, often with no or little market share, right? So there are good reasons why those challenges took a long time. But I think once it became clear that big tech was, in some cases at least, cutting off nascent competition, it made sense to start looking hard at these transactions and to challenge the ones that were anti-competitive. I think that's the job of the antitrust enforcement agencies. That being said, it's good to keep in mind what Anant raised for the antitrust enforcers, which is broad challenges to startup acquisitions might start to chill VC investment or founder activity. And I think you have to go pretty far in your enforcement activity to get there, but I think it's worth keeping your eyes on. In the article, the NYU article, we talk about various ways in which the Biden administration made merger activity more difficult. And some of these ways, at least I, just speaking for myself, not for my co-authors, I supported, right, which I think include challenging mergers where it looked like the goal was to kill off a nascent competitor. But there were other policies that seemed to chill merger activity more generally. For instance, ending the early termination option for emerging parties, sending merging parties warning letters that even though the 30-day HSR clock had wound down, that the agency still might challenge the transaction. So creating some uncertainty in the merger environment for startups. I think it's worth keeping in mind that if you create too much uncertainty, maybe you suppress some of that VC investment and some of the innovative activity that would otherwise be going on. But I'll circle back to my first point, which is to say, there's a law enforcement function here, and that's the first job, right? So if there is a merger that looks like it's anti-competitive, happens to be a startup being acquired by a big public company, it's the job of the enforcement agencies to try to block that merger. And whatever downstream effect it has on investment, VC investment or founding activity, that's not really their concern at that point. But more broadly, I think it is helpful for the antitrust enforcers to think about, well, what will happen if we really tighten the merger aperture in a bunch of ways? At the very least, I think it's good when you're doing that to think, well, some of these firms are going to try to evade the antitrust laws. And I think that's, as we were talking about before, I think that's what's happening with reverse acquihires. I think it's no accident that in the wake of tightened merger enforcement, we're seeing these transactions. It's a structure that allows a company like Google or Microsoft to affect a transaction that might otherwise be challenged, and particularly in the Biden administration, where they weren't entering consent decrees that might lead to long litigation.
Your article brought me around to that conclusion on the policy point, and I commend No Exit to all our listeners. It's a good read, but I was reminded as I was reading it, your section on reverse acquihires, about comments by John Sallet when he was testifying in front of the House Judiciary Committee, where he said the seminal Microsoft case would never have happened had Microsoft just purchased Netscape outright. And with this reverse acquihires, I can feel from the private sector just a sense of, if only just get out of the way, just let us do our thing. This is unnecessary for just how technology develops. But it is these little frictions, these little hurdles that I think are there for a purpose and create the fairness for the rest of the playing field. And I know there are times when the progressive community wants antitrust to be the solution to many things, but to me, this strikes me as a great example of there is a law here for the antitrust enforcers to enforce. And if we want the policy to be changed, then let's put that onus on policymakers like Congress. Don't make it antitrust responsibility to figure out which way to go on this.
Yeah, I completely agree with that. I mean, I think the antitrust enforcers have done a very good job of, pivoting and figuring out how to challenge these acquisitions of nascent competitors. And there might be some knock-on effects that policymakers don't like, and that's, I think you're right, up to Congress to sort out. And I want to segue from that. I think it's a good point, thinking about outside the antitrust enforcement agencies for a second. So, if you're thinking about the startup ecosystem, and this is a point we try to make in the paper, if from a sort of whole of government point of view, if you're trying to encourage innovation, you're looking at the startup ecosystem, and you have levers, right? So you have the securities laws and the antitrust laws. And you know that you're tightening the antitrust laws, or you're tightening merger review. And again, you might think, well, now folks are going to shift over their liquidity events to IPOs, but it's, there are lots of reasons why firms don't like IPOs. So if you're looking at the whole ecosystem, if you're a policymaker, I think it's helpful to consider, okay, well, we have these two exit options. We've made them both a little more difficult. So what's going to happen now? What are the hydraulics of the system? Or they're going to force firms just to stay private longer. Maybe that's not what we want, right? From a whole of government point of view, if you're sort of overlooking tech innovation policy, or thinking about the way that securities laws and antitrust laws interact, I think it's good to take that sort of that overview. And that's not necessarily the job of the antitrust enforcers, right? That's the job probably of Congress or of the administration. I'll make one more point here, which is, at least in the scholarly community, you have your securities laws experts on one side and your antitrust law experts on the other side. And we don't hear a lot about how those two regimes interact, but here they do. Here we have these two forms of exit for startups. For whatever reason, over the last 25 years, IPOs have become much less attractive to startups. We can talk about all those reasons. And mergers were the much more attractive option starting in around 2000. And then we have this period of, tightening the screws on mergers. And here we have the result, right? Which is firms aren't flowing back to IPOs. They're finding other ways to stay private.
So Sam, I think to start to wrap things up, one of the points that has come up a few times during the podcast is innovation and what reverse acquihires mean for innovation. We're seeing them mostly right now in tech and in AI, and it's simultaneous with, this race to build the best AI model in the US, and all of these companies trying to be that first company to get to, artificial general intelligence, et cetera. So are we going to continue to see these, do you think, only in big tech and AI, or do you anticipate that we might see them in other spaces?
Yeah, it's a great question. So we are seeing them so far, I think, only in AI. And I think, that's partially because it seems like in AI that the talent is so difficult to come by. So this is a way to acquire that talent. And we've seen, huge arms race in terms of, giant pay packages for the best engineers. I think unless, I'm just prognosticating, but I think unless the antitrust agencies say this is an HSR violation, we're going to see this structure in other sectors, though. Because if you're a big tech company and you want to acquire in some way a smaller tech company, and you can do it this way through what venture capital folks are calling a license deal, why wouldn't you? Right? Why wouldn't you do the license deal and avoid filing an HSR, which is expensive and uncertain? Just do this deal. And that as long as you can write a check that in some way passes the laugh test for something, and you can take the employees, this transaction structure makes a lot of sense until the government says stop doing it, right? And I should say, when if the government intercedes here and says this is an HSR violation, there are fines for these violations, but that's not going to matter to these companies. The point of an enforcement action would be to say, we see you doing this. This is an HSR violation. We're putting a marker down. And that might at least make the startup side of this think twice about entering these kinds of deals.
Sam, at the end of our Curious Amalgam, we invite our audience to get to know our guest a little better through a segment we call The Curious Hat.
And now it's time for The Curious Hat!
Lexi, do you want to go first?
Yeah, I'll take it away, Anant. So Sam, I know you're based in New York like I am, and I just discovered actually that you live not far from where I do. So let's settle this once and for all. I need to know, what is your New York bagel of choice?
Oh, it's the Bagel Hole on 7th Avenue in Park Slope. It's the best.
Oh, wow. That is actually one I've never heard of. So I'll have to check that out.
You should go. They're always warm, at least on Saturday and Sunday mornings. Bill de Blasio used to go, and there was some controversy when he was running for mayor, I think the second time, where he had asked for it to be toasted. And the guy who ran the bagel said, sorry, we don't do that for anybody. Can't have a toasted bagel.
Okay, Sam, according to ChatGPT, other famous Sam Weinsteins in history include a producer and a Chicago area bowling industry personality. If all of you were thrown into an arena in gladiatorial combat where every man goes in and only one comes out, which Sam Weinstein would be victorious and why?
Oh, I'm sure it'd be the bowling guy, right? That's got to be a cutthroat industry. Right?
He might even have his ball on him.
That's true, right? Just bowl it through us.
Okay, question 3 for you. If you were to hear one song every time you entered your classroom to start a lecture, what would it be and why?
Oh, that's a tough one. What jumps to mind is It's a Long Way to the Top If You Want to Rock and Roll by AC/DC.
Nice.
I don't know.
Nice.
It's just on my mind. Bagpipe solo.
I can see the dance moves now.
There we go.
Okay, and Sam, ecologists and conservationists warn of a butterfly effect where harm to any species, however small or seemingly insignificant, could have profoundly negative repercussions on their ecosystem. That said, would you support just rolling the dice on mosquitoes and trying to make them extinct?
In New York, I don't know if this is true in DC as well, there's something called a spotted lanternfly. And
yes,
the New York City government has told us that we have to kill these lanternflies when we see them. I feel the same way about mosquitoes. I'm not sure what mosquitoes are bringing to the table, so other than malaria. So I'm all for getting rid of them.
Excellent. Well, Lexi, this was a great idea. That article of Sam's and his co-authors, I was just struck by the policy implications about which way should antitrust go on this, and it really brought me around, I think, to a place that I hadn't started.
And Sam, Anant has had a long career in policy, so that your article was able to do that is some feat.
Well, I'm happy to hear it. It was great to get the chance to talk to you about it.
So thank you both, Lexi and Sam. For more on this topic, be sure to read Sam's paper entitled No Exit with his 2 co-authors that comes out in NYU Law Review. And for more great discussions and content, be sure to check out our other episodes of Our Curious Amalgam and current episodes of Trust and Trade.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.